Hello and thank you for joining me for this talk, which is titled "The Law Relating to the Internet is Inadequate." It will primarily focus on UK law, but there will be reference to other jurisdictions and what we think of as international law. I will refer to academic articles from Holland, Rhodes, Ramahi and Saadat and other reliable sources. So to begin with, what exactly is the Internet? Well, quite simply, it's a collection of computers connected to each other via a network and serving up content to each other on demand. And in 1971, the Internet was just 2 years old and had only 23 devices connected worldwide. Today, however, there are over 1 billion websites available on the Internet, millions of individual apps to download, and new products and services are becoming available every day, all of which offering new ways to purchase products and services, digital storage, and different and innovative ways to share things and communicate with each other, just to name a few. In fact, for every single second of this presentation, around 8,000 tweets will be sent on Twitter, 2,000 people will make a new phone call using Skype, 60,000 searches will be conducted on Google, and almost 70,000 videos will be watched on YouTube. The law, on the other hand, has a well-established reputation for being conservative and very resistant to change, taking months or even years for new laws to come to pass. So how can the law possibly hope to keep up with something as fast-paced, diverse, and ever-changing as the Internet? Larry Page himself has said that the law cannot be right if most of it was brought about before the existence of the Internet, and the House of Lords have referred that the Internet has a perception of being something of a lawless Wild West. So today we're going to discuss 3 key areas where we are all affected by the Internet to some degree, and some underlying legal principles that run through each of these areas. Possibly the most overarching legal principle underlying each of these areas, as discussed in depth by Saadat, Ramahi and Rhodes, is that of jurisdiction, because the Internet is available worldwide, and dubbed so as the World Wide Web in 1984, there have been very few, if any, restrictions on who can serve up digital content to a citizen of a foreign jurisdiction. Saadat commented that the US Supreme Court referenced the Internet as being in cyberspace, located in no particular geographical location, but available to anyone, anywhere in the world. Consider this, for example, in relation to the first of 3 areas that I will discuss that concerns all of us, which is safety and security online. If you receive an email or visit a website and make a purchase based on that, which jurisdiction is going to govern and protect that transaction? Now, you may feel that there's a sense of security if both parties are based in the UK. However, the Office of National Statistics say that there's over 6 million cybercrimes a year, and the consumer body Which says that if you are duped in such a transaction and try to recoup the losses from your bank, it's the equivalent of asking your insurance company to restore your losses after you've left open your front door. The good news is if you can identify the other party and they're in the UK, they are obviously subject to all of UK and EU law, which includes the Consumer Rights Act to protect consumers in purchases with businesses online, and the Sale of Goods Act still applies for business-to-business transactions or consumer-to-consumer transactions. But the law is still unable to adequately protect victims of outright digital fraud. As the Telegraph reported in 2016, a couple lost over £200,000 because a fraudster had gained access to their email account and emailed their solicitor with alternate bank details to receive a payment. Now, the Computer Misuse Act makes this and many things like it a criminal offence in the UK, but if the perpetrator, as they often are, in a foreign jurisdiction, then not only would tracking them down be almost impossible, but even if you did, it would depend on the 2 jurisdictions being in agreement with each other as to the offence and as to an appropriate remedy, which, as Rhodes discussed, is making it very difficult to achieve any sort of remedy in this kind of case. So safety and security online is an obvious concern in the UK, and the Office of Fair Trading's own research concluded that over 1/3 of UK citizens didn't trust the Internet enough to do their shopping there. The second of my 3 main areas of concern is that of privacy of personal data. Holland goes into great detail into what he calls the privacy paradox, which is where individuals do not wish to divulge their personal information, and yet their actions and online behaviour have the opposite effect by sharing huge quantities of their personal information with lots of different companies and websites online. Now, while the Information Commissioner's Office sets out certain rights and regulations with the handling of personal data in line with the Data Protection Act, Gamble nevertheless reported the Citizens' Advice findings that there's over 14,000 complaints of unwanted calls every month, and over 98% of people hadn't consented to those calls. And despite the rights outlined in the Data Protection Act, Professor Skilton said it's almost impossible to determine whether we own any property rights in our personal information when we've given it to another party online. Holland concluded that we can only control our personal data to the extent that we conceal or manage its disclosure to a third party. And although the Information and Commissioner's Office requires businesses in the UK not to send data outside of the EU, and an EU directive implementation requires an opt-in consent for collecting data, MARA still believes that the differences in jurisdiction and relying on consumer consent presents a sufficient problem to suggest that the law is inadequately protecting privacy of data. Indeed, the House of Lords said in 2007 that it is unrealistic to leave the responsibility of internet security with the individual user, and with the introduction of the Investigatory Powers Act, many IT companies are concerned that this poses a significant threat to the security of their customers' data, which they will be required to retain on their systems. Strong evidence reported by the BBC showing that more than £193 billion a year of fraud is due largely to the growth of the internet, and as it also reported Yahoo's breach of security of more than 1 billion accounts, again shows how the law is simply inadequate to protect consumers' data. The third main area of concern is equally exposed to the dangers of the internet, that is of intellectual property. In other words, the rights to music, film, ideas, written content, and so forth. And again, although we have trademark and copyright laws in the UK, Ramahi writes again that it is only as effective as it is limited to the jurisdictions to provide adequate protection for the rights holders for that copyright. Even with the Berne Convention, administered by the World Intellectual Property Organization, set up specifically to protect literary and artistic works, with 164 countries signed up to it, the problem is still prevalent. As Williamson writes, major film companies alone lose £2 to £3 billion a year due to copyright theft on the internet, showing that even with such laws in place, it doesn't protect the theft of intellectual property. Williamson also writes that the most suitable defendant is one that can be found, brought to court, and has the money to pay sufficient compensation. He concludes that not only is the current law not satisfactory, but even complex statutory additions to existing law might still provide only a temporary and unsatisfactory answer, because technology is simply moving faster than the law. In some cases of intellectual property infringement, such as domain name disputes, the World Intellectual Property Organization has a process called UDRP, which offers an inexpensive way to seek a remedy for such infringement on a domain name. However, Mosaica describes the whole process as flawed because the procedure allows for the infringing party to bring the case in their national court and halt the process. Thus, anybody in the UK would be halted in such a claim and left with perpetual difficulties in protecting their intellectual property. Trancada writes about the experiences of a former Hollywood executive with more than 40 years experience in the industry, now becoming a lawyer. He believes that the Digital Millennium Copyright Act, whilst designed to protect copyright, has actually provided a safe haven for the likes of Google and YouTube, which brought worldwide attention in the case of Viacom against YouTube, which decided that even though there was knowledge of the infringing activity, this was not sufficient to constitute infringement in and of itself. For UK internet users, not only are they required to agree to the YouTube terms of use, but any of their intellectual property may be uploaded to YouTube and subject to the DMCA and not necessarily protected adequately in law. As one final illustration, Rhodes talks about an English case of Jamil versus Dow Jones, where the Court of Appeal said that they didn't want to spend much resources on the case of defamation because they felt that there was so little at stake. So in conclusion, whilst there are some wide-sweeping legislation and international treaties in place, the cross-jurisdictional nature of international disputes and modern application of old law renders the law simply inadequate to deal with the modern complexities of the internet and offer sufficient remedies. I hope you enjoyed the talk and thank you very much for your kind attention.